Liborous, I want us to look at the technicalities here that the Supreme Court mentioned. Are those technicalities, um, is the technicality valid?
What the Supreme Court is saying that if you are since you are alleging irregularity, you are claiming that the election was fraudulent, that you ought to have come by way of writ of summons, that we allow you to call witnesses to prove this fraud, and then allow the other man to also call witnesses to counter.
Is that what the law stipulates?
Yes, that's what law says. Once fraud is alleged, but also the law also says that for pre-election matters,
okay,
you must come by way of originating process because of time. Because of time, that's the position of the Electoral Act. You must come by originating process. But in this case, let's even look at it, assuming without conceding that yes, the Supreme Court is right in that direction. Also, the issue of cancellation of primaries.
Yeah.
Why didn't the majority judgment mention it? That, this primaries was cancelled. And so they have power to conduct another primaries. So on the face of that fact, that the primary was not cancelled, every other thing falls flat on its face with secondary. So you can't even now be talking about fraudulent, irregularities, and the rest for that second primaries because it was not validly conducted in the eye of the law because there is a subsisting primaries and results had been announced, and that primaries had not been cancelled. So why can you conduct two primaries at the same time? Which one do you don't want INEC to take? So that's the problem here. That's the big challenge. So assuming that, yes, he didn't come by way of writ of summons.
Right.
But the major question, let's even take what the Supreme Court usually do is, okay, let's take a position of law. We agree that it ought to have come by way of originating summons on the issue of fraud and the rest. But there's a position of law here that the primary itself was not cancelled. So since it wasn't cancelled, in the eye of the law, it is valid. So since it is valid, the second one is a ruse. Involves all of us.
Do you think, Liborous, do you think that the Supreme Court could have ordered for a rerun of the primaries instead?
There's no need to begin to talk about a rerun of the primaries that is valid, that was not cancelled. The time for cancellation...
But is that a possibility looking at the time frame left now? Is that a reasonable possibility?
No, that is not the position of the law. We can't be talking about conjecture. You cannot... Section 33 is clear. Once a candidate is nominated, it can only be substituted except on grounds of withdrawal or death. So, in this case, the man says, I will not withdraw. So, I came to you and asked you. You say you are not interested because you believe that the powers that be want to gift you the presidency. And so, you voluntarily withdrew from the race. So, you were not even a party at the lower courts. So, at the end of the day, now election has been concluded. That gift that you were expecting was not given to you. I have pressed the tape, and then they are giving you the medal. Have you seen that? We went for 100 meters. You were on the line for the race. They now told you, don't worry. Come and run the 200 meter. We'll make you win. We'll disqualify every other person. And then you withdrew from the race. And we ran the race. I pressed the tape. And then that other 200 meters we went to run. You know, somehow you didn't win. You're coming back to the 100 meters and they're giving you the medal. And the Supreme Court is saying this first 100 meter race that was run was not cancelled. So there was no need for another one. So even if you conducted another one, it is not valid. This reminded me of what my son just complained of about 2 weeks ago that happened in Abeokuta.
Okay.
For World Athletics Federation, amateur 100 meters, 200 meters, and the relay and the rest. Under 12, under 16, under 15, and under 17. He said they got there, and somebody will sit down, stand up, and say, "Oh boy, this under 17, he's tough. Oh, let me go to under 15." And he was not asking himself, so can somebody else downgrade his age like that? This is stark reality for him of what Nigeria is. That is the first time it's coming out. This is an amateur
he got the rude awakening of what Nigeria is.
Awakening of what Nigeria is, and he came back to me to say, "Daddy, is this way it is done? That somebody will live under 15 and go to under 12, or that somebody who is already an athlete running the national, competing at the national sport festival will come for amateur, where you want to select future stars, and the organizers, the members of staff, FIFA badge recognized athletes will be arguing and debating it, the rightness or wrongness of it." And I told my son, I said, "Unfortunately, welcome to Nigeria." Toby Amosu probably passed through this same thing in the same Ogun State some years back, but when she got to America, she was recognized. So don't worry, don't be discouraged. Pass through the process, and someday when you also get abroad, if it was a unanimous decision, you will now begin to think and say, "Well, maybe there's some element of let's even try to reason with them." It is 2 against 3. It is 2 against 3. And so you read the minority judgment, it resonates with the common man, it resonates with the reasonable lawyer more than the majority judgment. What it even means is that even the judges are not in agreement.
Yeah, that's what it means, yes.
So if the judges themselves are not in agreement on it, you can understand the sharp division amongst senior lawyers, not talk of junior lawyers. So the ordinary man, that little hope, that fragile hope that they have in the process will just vanish